before we jump into the questions, we have over 30 today, which is amazing. I just want to make a quick mention. If you enjoyed today's presentation or you have constructive feedback on how we can improve, please consider leaving our firm a review on Google or on Yelp. We are sharing a link in the chat now on how to do a review. We are always happy to get your feedback, and it's really important to get feedback so that we can provide them to the different cities, towns, and municipalities, neighborhood services departments, that these classes are valuable so that they continue doing them in 2025. I know we're going to be having a meeting with them shortly to talk about programming for the second half of 2025. So it's really important. If you wouldn't mind, I would sincerely appreciate it if you wouldn't mind giving us a review so that we can then share those comments with the different neighborhood services departments that are asking me to teach these classes so that they continue doing them in 2025. Also, one thing before we flip over to the questions, we had over 188 attendees today on Zoom. I think that might be close to a record. So thanks so much, everybody, for being here today. Really appreciate you caring about your community so much. Okay, let's go right into the questions. Question number 1 is from a board member. We have a rental property that appears to have been abandoned by an out-of-state owner. The house was involved in criminal activity over a year ago and still stands with boarded up windows and overgrown vegetation. What would be the legal options we could take to force compliance? Does the city of Tempe have code violations that we could enforce? We know we could take over some of the exterior maintenance and pass the cost back to the owner. The owner is current on the monthly assessments. Okay, that's a good sign. So 2 things I would do here. Number 1, contact the city of Tempe code enforcement and see if tell them about the violations, see if they will open a file on it and possibly come out and do a citation. The second thing is it's really good that this owner is paying assessments. So that means they're responsible. They don't have an intent to abandon the property. I would consider sending a violation letter to them and fining them. Also use your self-help, like you said you have in your documents, to get them to, comply. Self-help means that, you're telling them about the violation, giving them an opportunity to cure it. If they don't cure it, you go in and fix it and then charge them for it. If it continues to escalate, you may want to turn it over to our firm to help you, or your law firm to help you write a violation letter to them and to threaten any legal remedies that we may have. Okay, second question from an HOA. Can you explain votes to be cast in person and describe how to meet in-person ballot requirements if a membership meeting is held online? Due to prior voting fraud of ballots cast in person, our association has a secured online ballot available in each owner's portal and a written ballot available upon request. The written ballot is accepted either by mail-in or in person, up to a deadline that is typically 3 to 5 days before the membership meeting, giving the association time to verify. The secured online version is accepted anytime up to the call for ballots at the membership meeting for anyone attending the online meeting in person. Would this process meet the ballot or voting requirements for in-person voting? I think yes, it does, but I would add one additional thing to make it 100% legal. I think you have to allow the opportunity for people to vote in person at the meeting. That's what the law says. It says, they must be cast in person. Association shall provide for votes to be cast in person and by absentee ballot. So my recommendation would be if somebody shows up at the meeting and they want to cast a ballot in person, you should allow that. Now, virtual meetings pose a special challenge. So maybe they scan a picture of it to, an email and send it by email. I mean, I honestly haven't seen a lot of voter fraud on something like that in person. And we've accepted ballots that way, or maybe they text it to a designated person at the meeting if everything is virtual, or maybe there's an in-person component to the meeting and the person's right at the meeting and they just hand it in to the person, from the association, the manager or the board, if they're having the meeting in person. Okay, next question, number 3. Is there an Arizona statute that specifies the maximum number of days that HOA members have to pay their monthly dues following the first day of the month to avoid a penalty? Yes, I don't know if you are a planned community or a condominium, you're saying you're an HOA, but, under Arizona law, a payment is deemed late in a planned community if it's unpaid 15 or more days after its due date, unless the declaration, bylaws, or rules of the association provide for a longer period. So that's the rules for HOAs, planned communities. In a condo, you have to look at what the documents state, meaning the CC&Rs or the bylaws. Typically in a condo, we just suggest that you follow the Planned Communities Act because it's a reasonable standard. Okay, next question, number 4, from one of my favorite board members, former board members. Can you have flag restrictions in your rules and regs? Because there's a state law that talks about flags, I think it is potentially allowable that you could do that. I mean, there shouldn't really be any question marks about flags because state law is very clear about what flags can and can't be flown in an association. You know, and I'd like to see how broad your rulemaking authority is, but generally speaking, I would say yes. And if you have any questions about what flags can and can't be flown, check out our top 10 things you need to know about Arizona law cheat sheet. We have a good subject of those in there. Okay, next subject or next question, number 5. Can boards vote or make decisions during an executive meeting, or should that be done in an open meeting, yet still protected and not anonymity of the parties involved? So in my opinion is yes, boards can make votes during executive sessions. You know, I typically don't, you know, tell boards to go back into the open session to, you know, state what decisions they've been made. I don't know any associations that do that. Okay, next question, number 6. If our bylaws allow owners to assume dual roles such as secretary treasurer, are there any state or other regulations that do not allow this option? So no, I'm not aware of any state laws that would prohibit that. Maybe your documents might prohibit it, but there's no state law. Question number 7. Some homeowners gathered signatures for a homeowner town hall. We will have a meeting moderator. We will have common sense rules such as no yelling, don't get personal, state your concern, and then offer solutions. I've looked at your annual and board meeting cheat sheets. Do you have any advice for a homeowner-led HOA town hall meeting? I do kind of have some advice on this. So I know under the law in Arizona, the homeowners can have their own meeting, you know, where they are able to talk about issues, and the board has to allow that. I mean, I guess just don't make it a free-for-all would be what I would say. If you're upset about something, you know, having a meeting of the homeowners just to rile people up and get upset does just that. I mean, probably the more common sense approach would be to ask the board to be there to answer questions. I mean, obviously you're going to be moderating it, but, you know, give the board an opportunity to listen and to offer solutions and to give their insight into things, versus just like a rile up people meeting where everybody's yelling and screaming and nothing gets, you know, handled, and it just creates unrest in your association. Okay, next question, number 8. If a board seeks to exclude the members when the meeting should be open, what can we do? Really good question. So what do we do if the board's violating the open meeting law? Document it in writing, number 1. Get an attorney if they continue to do it and have the attorney write a letter. Consider going to the Arizona Department of Real Estate. They have a platform where you can file a complaint against the association, and there's a hearing in front of an administrative law judge. Or consider litigation. Consider running for the board yourself. Consider removing the board under the requirements under state law. So those are like a lot of different suggestions on things that you can do. Question number 9. We own a majority of our streets, but the city paves and maintains them. I cannot find any records showing the streets were dedicated. Where would dedication records be located? I have copies of recorded documents where the golf course in our community quitclaimed them to us instead of the city. So you need to just look at the plat map for your association. That would be a starting point. And then I would also look at, it should indicate on the plat map if the streets are dedicated to the city. But I'd also have a title company check to see if there's anything else out there that might be, you know, applicable to this situation. If you need the name of a title company and somebody that might be able to do that, just reach out to our office. We're happy to help. Okay, next question, number 10. What happens if you are not able to achieve a quorum to hold the annual meeting? Oh, good question. I'm glad you asked that question. So if you don't have a quorum at the annual meeting, there's a couple things you can do. You can not hold the meeting that night and try to renotice it Some association documents have a lower quorum requirement for the renoticing of the meeting. So that's something that you could definitely, try. If your documents say, like, if the first attempt fails, the quorum is divided in half or whatever, you can do that. You can try again. You can just cancel the meeting for that night and totally renotice the meeting and do a reset on it, try again. You can have an informal meeting that night and just go over what you would have done if you were going to have a board meeting or an annual meeting, but you just don't have a quorum. If you do it that way, though, your directors, nobody's elected, right? So you have the existing directors just stay on another year because they don't lose their spot until their replacement is elected. So if you get into that situation, probably a really good time to check in with your trusted advisors who are your attorneys, just to say, like, okay, where is this going? Like, why are we not getting a quorum, and what can we do to get a quorum? Because I find that associations that have multiple years of not having an annual meeting, usually there's some level of dysfunction there. And it's important to try to get a quorum and conduct the annual meeting to elect new directors. Okay, question number 11. Can you provide some general comments regarding using a professional financial advisor to manage long-term reserve funds? I mean, I can give you the general comments is only invest in very safe investments. I don't do anything that's high risk. So you should be doing safe investments. This is not, something where you put it into high risk investments. Okay, number 12, we are a sub-HOA with a large master association. Our sub-HOA operates private streets. Most sub-HOAs in the master have public streets. The master HOA claims that if the public roadway control vote passes, every sub-HOA homeowner would face a substantial increase in quarterly master fees. That's strange. Under what conditions would private road sub-HOA homeowners be exempted from this proposed master association fee increase if the public road control vote passes? Things that make you go, this is one of those questions. So I have no idea why this would be a substantial increase in quarterly master fees, because they're currently, the master association should already be enforcing on-street parking on their streets that are dedicated to the public. And so there shouldn't be any extra cost. I mean, maybe they're saying, well, now we have to invest in like an overnight parking patrol or something, but they weren't doing that before. And basically the vote is just to keep having the right to enforce it if the board so chooses, the master board so chooses to enforce it. So something doesn't smell right here to me. Like, it's almost like they don't want, to have the public roadway control vote pass. And one way to ensure that that happens is to say that we're going to have a substantial increase in the quarterly master fees, which is kind of upsetting for me to hear. I don't like seeing stuff like this. So my experience is that there's no change in the costs. It's business as usual, because you've been enforcing the on-street parking, or they've been enforcing the on-street parking for many years. So why would there be any change, in the cost? And basically you're just preserving your right to be able to continue to do it. It doesn't force you to have an off-duty police officer patrolling now or anything like that. So, would you be exempt? Under what conditions would private road sub-associations be exempt from this? I mean, honestly, I think it's just a scare tactic. And I mean, I'd have to look at your CC&Rs to see if it would apply to you. I guess any increase that the master association does would apply to you, but they have to justify it. And I'm not hearing the justification on that right now. Question 13, our bylaws state that for our annual meeting, that if the nominees do not exceed the number of vacancies, then voting at the meeting shall be by a show of hands. We do not have nominees that exceed the open vacancies. Is the show of hands at the annual meeting acceptable? I mean, I would never be on board with the show of hands for electing on anything at the annual meeting. So I'm going to say that even if your documents allow that, I wouldn't do that. Okay, question 14. You need to have the paper trail of the ballots in case it's questioned. And, a formal vote through ballots is the way to go. Okay, question number 14. Are board members required to have their video on during Zoom meetings? Some frequently don't. Well, I don't know. I guess as a board member, sometimes I turn my video off for a second too. If, something happens where one of my kids is asking me a question or something, I put mute on and I turn the video off. I mean, I guess here's what I would say is that, if you think that they are taking their video off and they're not listening or they're leaving the room and they're not there, that's one thing. If they're, shortly just taking it off for a second so that they can deal with something that they're dealing with at home during the meeting, and it's infrequent, it's a 1 minute thing, I really don't think that's that big of a problem. But the best thing to do is just talk about it as a board. If it's a problem, the board should vote, a majority of the board rules. So if a majority of the board says keep the, the video on, then everybody's got to keep their video on. Okay, but it's not required. Question 15. Please clarify that 48-hour notice is required for an executive meeting that would include its agenda as well. Yes, you need to get 48 hours in advance of the executive session meeting, and my interpretation of the new law from last year is that the executive session also requires 48 hours notice of the agenda. And remember, the agenda has to state with particularity which section in the executive session open meeting law you're going to be discussing at that meeting. Okay, next question, number 16. We are one of the associations that learned our association insurance will not be renewed. Oh, sorry to hear that. Our current policy expires on March 1st. I only learned of the non-renewal 4 weeks ago. I'm working with the broker to identify new insurance. We are going to discuss this topic at our annual meeting this Friday. What if our coverage lapses before we secure new coverage? Should I be doing anything more? I'm getting this question a lot from associations, so I'm glad that you're raising it in this forum. I mean, this is happening. I mean, a lot of associations are, being non-renewed, or maybe their company's saying we're no longer writing policies in Arizona. I think you need to get very active in finding companies that are still able to write policies in Arizona. There's one, contact my office. I think it's like Honeycomb. I can't remember the exact name of it. I have it right, in a notebook in my office, where this particular insurance company is writing policies in Arizona, and they're very favorable rates. So email me later today and I'll give you the name of that company. It's like Honeycomb, I think Insurance is the name of it. And they are have successfully been able to insure some associations that had their insurance canceled. But you need to be out there, definitely calling insurance companies to see if, you can get insurance through them. Lapsing the policy is really not an option, in my opinion. So we need to use the next, week and a half to really focus on getting this taken care of. And I'm happy to help you any way I can. So reach out to me. Okay, question number 17. How to approach the board if they do not provide notice or agenda prior to the meeting? Well, you can give them a copy of our cheat sheet. You can give them a copy of this video, which will be on Facebook Live today. If you want to see the video today, as soon as the presentation ends, it's posted on Facebook Live. Also, in a couple days or a week or something, it'll be posted. This video will be posted on our website. Just let them know, hey, I went to this seminar and the attorney talked about this and we're not doing it, and we really need to be doing this. And so, what I would recommend is showing them, hey, this is something that we're required to do under the law. Please, let's comply with this going forward. If they don't do it, then, you may have to go the route that I was talking about a few minutes ago. Hire an attorney, document it in writing, hire an attorney, ADRE hearing, lawsuit, run for the board, remove the board. Okay, next question, number 19. Oops, question 18, excuse me. Our HOA president has separate meetings with 3 board members and does not notify the other 2 members. Community is given no notice. Community is never told what executive session pertains to. Though our president breaks the rules, the community seems helpless. That's not good. Okay, so it's a violation for a quorum of the board to meet without, having it an open meeting and inviting the other 2 board members. So, I would document in writing your concerns on that. The community not getting notice is the same question as before. Document your concerns. you know your legal remedies. Hire a lawyer, ADRE, lawsuit, board removal petition, or you run for the board. Same thing on, telling the owners what executive session, you're going into executive session to discuss. I mean, all of these things are provided on our cheat sheets. Give them to your board and say, listen, you need to comply with the law. Okay, next question, 19. We are a community of 7 HOAs and are self-managed. We have a general manager, assistant property manager. Our HOAs have not had any of our self-management attend our HOA meetings. Are they required to have a GM or assistant attend our board meetings? Okay, so it looks like you're a large master plan community. You have a general manager and assistant property manager. HOAs have not had any of our sub-associations attend our HOA meetings. Are they required? Probably not. So, like, for example, I'm on the master board where I live, and I'm also on the sub board. So our sub-association manager never comes to the master association board. I mean, occasionally she may be listening in, but it's irregular. So, okay, number 20, our board does not post an agenda when they have an executive meeting. Is this legal? Are they obligated to do this? So yes, they are obligated to do it, but I mean, they're not going to, it's an executive meeting, so they're not going to have that much detail. Basically, the agenda should just state which section under the law they will be discussing during the executive session, during the closed session. Okay, next question. If your HOA does not have architectural meetings and the committee renders decisions on a software program, does the decision on an ARC request need to be unanimous? Well, I guess it just depends. Is this a regularly scheduled committee meeting? If it is, then you're required, to have this be, like an open meeting where the members are allowed to attend and listen. If not, then it may not need to be an open meeting. I guess the baseline question that I tell all my clients on this, and this is from a manager that I really like working with, good to see you here today, is, my recommendation is if your board is doing architectural meetings and you're maybe doing them electronically or by email, what I recommend that you do is, have a paper trail on it and have the paper trail somehow associated with the board meeting so that you can read into the record that these things were approved or disapproved. So there's some paper trail on it. And if it's going to be something that's really controversial, what I recommend that you do is not, have an open meeting, because if you're going to get sued on it, just do everything by the book on it, because, you want to have an open discussion. You should have homeowners there that are upset about it, a homeowner that's actually trying to do it. So you can have a good dialogue so that we avoid a lawsuit. And if there is a lawsuit, there's also a really good paper trail with meeting minutes, etc. So short answer, does it need to be unanimous? Well, it only would need to be, I never like to get into this unanimous consent outside of a meeting thing, because my opinion is board should not be making decisions by unanimous consent outside of a board meeting, except it's like if it's an emergency, and then it doesn't even need to be unanimous consent. So architectural committee is a little different because you're only subject to the open meeting law if you have regularly scheduled architectural committee meetings, and it doesn't sound like you do here, so I don't think it would need to be unanimous. Okay, question 22. Do you really have to provide printed hard copies of the agenda for resident attendees of a board meeting? Is it not sufficient to provide an electronic copy via email or post it on a website with the ability to print? If a hard copy is required, is this by law? Which one? It does just say that the agenda has to be, provided to the members. It doesn't say it has to be, physically provided, or that, it can't be electronic. So I would just make it readily accessible so that people who come to the meeting have access to an agenda. Okay, next question, 23. If there is a presentation as part of the board meeting, should that be attached to the minutes and shared with the community once the minutes are approved? I don't think the presentation would need to be. I mean, a presentation, you just say in the minutes, presentation was given by ABC Landscaping Company, but you don't have to attach that to the minutes. Can the board meet without the property management company present and just update them via meeting minutes? Yes, that's fine. I mean, the board makes the decisions on that. Does the secretary or the community manager document the minutes? It really depends. Most managers do it because they're there, but there may be times when, the secretary or the attorney may help out. Really, the board just makes the decisions on all of that. Okay, next question. Let's see, number 24. Looks like we're up to about, we're getting a lot of questions, 38. Okay, so question number 24. If the board wants to discuss in executive session an item referring to another board member, like their conduct or a possible fine, can they exclude that board member from that executive session discussion? So if a majority of the board agrees to that, yes, they can. But it has to be, you have to tell the board member that you're excluding, this is what we're going to be discussing. We're only discussing this. And honestly, I think you should give them an opportunity to be heard. If you're giving them a fine, they have to have an opportunity to be heard under the law. But also on their conduct, I think you could talk with them first. And then if the board's going to vote and discuss on it after that person leaves, that's fine. Okay, next question, number 25. Are there legal requirements for an HOA using Facebook group to inform residents? We do not have a real website or an online place to get any info. And when the board was asked, they stated Facebook cannot be legally used. Just looking for clarification. I mean, I think it would be, there's no legal requirements for that. Okay, but there are some requirements that you have to, provide notice of regular board meetings, etc. So if you're posting them on a Facebook group, that's great. But that may not be, you may not be reaching everybody in your community by doing that. So you should also have another way to notify your residents. It sounds like you don't have a website. Maybe you need to put up a bulletin board or have sandwich boards out to, get the notice out to the residents, any resident that's not on Facebook. Okay, question 26. With the pending 2025 legislation, will these rules and guidelines apply to all HOAs or just ones that are in cities? For example, Gilbert is a town and our HOA does just whatever they want. So good question. So if these are state laws, so they will apply to any HOA or condominium in the state if they pass. Okay, next question, number 27. I'm a new board member. I was told I'd receive information within the first month. Was even going up to the office, but as of now, I've not received any of that. I'm a homeowner who really represents homeowners, and I do not feel welcome on the board. How should this go? How do we actually transition back to a homeowner-friendly association? Okay, really good question. And just so you know, when I got on my board the second time, I was a little bit persona non grata too. So I understand how you're feeling. The word that comes to mind immediately is patience. You have to be a little patient because, patience on some things, but, you should be, informed of everything that's happening on the board, just like any other board member. Now, I don't know how long. A month is kind of a long time, in my opinion. So they should have, provided you with, if there was a meeting, usually boards are meeting every month. So you should have received like your board packet for the meeting, etc. One way that I think I would handle this would be I would email the manager and the rest of the board members and be like, I'm so excited to serve on the board. Thank you, for this opportunity. Look forward to working with everybody. I'm please asking that you include me on any communications going forward regarding, board business. And then you just have to be patient because it sounds like you're one of many on the board and, just work hard, be fair, resist the urge to, be difficult, so to speak. Try to work together with the existing board so that there's a mutual respect. You may not agree on everything, but try to get the mutual respect going and go back to the basics that we're all on this board because we care about our community. We may not all agree on how we get there and what decisions we're making, but we all care about our community and want what's best for the community. How do you transition back to a homeowner-friendly association? Well, I think at every opportunity, your association, in the meetings, you should be, saying like, hey, can we do this to make people feel more welcome or, try to implement some things from a grassroots effort to get people feeling more like this is a community versus less of a dictatorship or whatever, you think your community is feeling. And get more like-minded people on your board at the next election too. Okay, question 28. What can be done about a board member that overstays their term? The current president posted that there was only one position open, but failed to add his position, and another board member that had not been elected. So I'm not quite sure. I don't know all the facts on this, but sometimes I see boards doing like a little dance on the terms. And so maybe the board president resigns from his term, or her term 2 months before the annual meeting, and he gets appointed or she gets appointed to another term that's, a longer term. To me, that sounds like that person is insecure that they can't be reelected. And that's kind of problematic to me. Like I could never imagine doing that on either of the boards that I'm on. And so there's some underlying dysfunction when I hear this happening. But so it probably is legit. I would ask for the meeting minutes as to, why they were saying their term was on, you're understanding the term was up blank. I'm sure they're probably going to give you a meeting minute showing what I said. If that's not the case, then maybe you get an attorney, have the attorney take a look at it and see if what you're saying is a violation of your documents. Okay, question 29. Our board allows homeowner comments on each topic after the board discusses and before the vote on the motion. Yes, that is legal. The 2 times that a homeowner can talk during a meeting is during the homeowner forum if the board so chooses, and then before the board takes formal action on any matter. Now, usually the comment from the homeowner is going to be limited to like 30 seconds or a minute, but they are allowed under the law to do that. Okay, question 30. We have virtual meetings during the year. Do we need an in-person annual meeting? So my feeling on that is no, you don't. Yes, as long as you're having meetings, the meetings can be virtual or in person. Question 31. Does the ballot need to be a secret ballot? Some of our owners want a secret ballot. No, it doesn't, unless your bylaws require it to be a secret ballot. And honestly, I don't like using secret ballots because if there's a lawsuit or something on it, we like to be able to trace back all the ballots to the homeowner. Okay, to each homeowner. Okay, question 32. We are self-managed, 36 units. Our board can be 3 or 5 members to keep it uneven. We rarely have more than 5 volunteers. Since we only have 5, are we required to have an election? So, okay, so you're self-managed. You can have 3 or 5, but it has to be uneven, and you never have more than 5 volunteers. You still have to have the election, even though you're just rubber stamping it. In my opinion, is you still have to have the election. Question number 33, and just to give you kind of a quick update, we have 39 questions total today. What is the current industry status concerning local area property management companies? Our board's experiencing challenges with communications from the property manager. So yes, I would say that is a very common complaint that I hear, but not every management company falls into that category. So maybe reach out to us if you want to talk about that more, and we can maybe point you in the direction, hear more about what you're experiencing and where you're located and what your needs are, maybe point you in a direction for a management company that might be a better fit. Okay, question number 34. I am a homeowner. Can we make our HOA comply with Arizona law to give an agenda for the executive meeting? So yes, they should be doing that. I would give them our cheat sheet that talks about this, number 1. I also would, send it to your manager, but I'd also find out who the president of the company is and send it to them too. Just say, here's a cheat sheet on this topic. We don't understand why your manager isn't complying with Arizona law and giving us an agenda. Now remember, the agenda can't be, like that detailed, because what they're talking about is executive session confidential. But they do have to state what section in the open meeting law executive session exemptions they're going into executive session for. Okay. Question number 35. If an owner in our community threatened to make a scene at our upcoming annual meeting due to a buyer's failure to close on their lawn, the buyer's agent has threatened to attend the annual meeting. I want to confirm that I have the authority to ask this realtor to leave the meeting, as this person is not statutorily allowed to be there. Yes, you can ask a non-owner to leave. But if the owner gives the non-owner a written designation to be their designated agent, they have a right to be there. So that would have to be in writing. Okay, next question, talking about board member resignations. So this particular question says, how do we handle board member resignations? Basically you just need to look at your association's documents and read, like, if a board member resigns, like, how did the bylaws, reflect that? What rights does the board have to fill the vacancy? It's usually in your bylaws. Question 37, if a new board is elected in November for the next year, do they have to begin serving right away or wait until January 1st? I mean, it really depends. Most boards are elected and they start serving like the night of the annual meeting, but some have this weird kind of like waiting period where it's kind of a gray area where it's like, I'm not technically a board member until January 1st. So I would see it as a good time to get up to speed on issues. And, but I'm not sure if your bylaws have it written that way, that you may not be able to be a voting member until January 1st. Question 38, if your dues won't cover an HOA management company, we can only increase 5% a year, which is $10 per homeowner, $500 per year increase. A special assessment doesn't allow this in our CC&Rs. How could we achieve this, or do we continue as ourselves? Okay, so you want to get an HOA management company. You have very small limitations on how much you can increase your assessments. We can't do this with a special assessment. How do we do this? Well, typically you need, I don't have your CC&Rs, but typically it says like you can increase it X amount. If you want to go over that, you have to get a vote of the membership. So you probably need to be going that route. And also you want to make sure you buy in from your homeowners to go the, hiring a management company route. So having a vote of the membership to increase it higher than that to cover whatever the management fees are going to be is a good idea. Okay, next question, number 39. Should meeting minutes be posted somewhere so that homeowners know what was discussed? If so, how soon after the meeting should they be readily posted? So most associations now are posting the meeting minutes for the regular open board meeting on their website. And they're usually about 45 to 60 days behind the other meeting. So, the reason for that is, okay, so we have our meeting, let's say my board's having their meeting on Thursday. So we take the meeting minutes, but they're in draft form. We don't approve them until the March board meeting. And so after they're approved, then they would be put on the website. So it's, usually going to be about somewhere between 30, 45, 60 days till they're up on the website. Okay, last question. Can a trustee or manager of a condo unit be a board member? So I have to look at your bylaws. Typically in order to be a board member, you have to be an owner. And so I don't know, a trustee of a trust, that probably is enough to be a board member, but the manager, if they're not a record owner, then they, likely can't be a board member. But a manager of an LLC, yes, they could be. And the LLC owns the property, yes, they could be a board member. So I'd have to know more about your association. So first things first, what does it say in your documents to be a board member? Typically, it's going to say you have to be a record owner. If the record owner is a trustee of a trust, yes, they can be a board member. The trust owns a property, yes, they can be. If the manager is a manager of an LLC that owns a property in your association, yes, they can be a board member. If it's the manager, like the property manager of the condo, and they're not an owner, then likely no. Okay, so we got through a lot of different topics today, hour and 44 minutes. Great job, everybody. Thanks for being here. We're at the end of our questions, and just want to give you a quick update about 2 learning opportunities we had in March. And we're also working on our class topics for the second half of 2025 for our virtual HOA Academy. So stay tuned. We will be announcing those likely sometime in March or April. Okay, so first things first, we have our live virtual First Friday event on Friday, March 7th at 9 a.m. So the first Friday of the month. You can find out more information on that on our website. And then we have class number 3 of our 2025 virtual HOA Condo Academy, and that is on Tuesday, March 18th. We're going to have some cobwebs in our eyes because it'll be the day after my favorite holiday of the year, St. Patrick's Day. And on Tuesday, March 18th at 11 a.m., we're going to be doing our 2025 virtual HOA and Condo Academy. And we're going to be talking about safeguarding the financials of an association. So we're going to talk about reserve funds, insurance, preventing fraud and embezzlement. It's going to be a great class to talk a little bit about finances, how to protect the finances of the association, reserve funding, planning for the future, insurance, very hot topic right now with a lot of insurance companies not choosing to write policies in Arizona anymore. So it's going to be a great class. Hope you'll be able to join us for it. So I hope everybody has a great rest of February. Take care, and we look forward to seeing you at our classes in March. Bye, everybody.